Getting back to the raise the age part here. Now, what happens is if a person gets arrested, and there's different dates. So at one time, they just increase it to 16, and then by 2020, they increase it to 17. But the mechanism here is if you have a youthful offender type of incident, it goes to the youth part, or the youth court, correct?
Actually, again, I think this is where the terminology comes in. Technically, it's a juvenile offender. If you're a juvenile offender,
Okay.
which means you've committed a violent felony or one of the other serious cases, then yes, it would go to a youth part, but that's adult court. So
Right.
it's not family court.
Yep. Now, have you read the bill that the governor's put forward?
I've read most of the bill, yes.
Okay. And there's a part there that those crimes, where it's a serious crime, and it's called the youth part in the bill. The DA and the judge can agree, even though it's a violent felony, and these are some horrific crimes, when you look at it, they can send it to family court, correct?
In some instances, with the consent of the DA, in other instances, the DA has to affirmatively move, and then there's a list of criteria. In some instances, with the most serious cases, judges would be required to hold hearings and actually make findings before they could do it. But yes, there is a mechanism with the consent or on motion of the DA and with the judge agreeing that the circumstances exist that would justify sending it to family court that can be done. And I think it's important to point out, that's no different. If you have someone right now who's charged with rape in the first degree or murder in the second degree, and they're 15 years old, there are provisions that allow those cases to be removed to family court right now from adult court when they're charged as a juvenile offender. So it's not a new or a novel concept. What this bill adds is the requirement anytime a 16 or 17-year-old wants to have their case removed from adult court to family court, you either need the consent of the DA or it has to be on motion of the DA.
Yeah, but in this case, we're actually talking about if a person is 1 day short of their 18th birthday and commits a crime. But there's another section when you start reading into it where they put in there that upon motion of the defendant, right, and they don't mention consent of the DA. So that can be interpreted that upon motion of the defendant, the court, on its own initiative, can send this to family court.
I just got done reading. It's 72220 subdivision 4, and given my reading of the bill and my reading of that provision, I don't agree. As I read it, for 16 and 17-year-olds, those provisions, to me at least, make clear that it would require either the consent of or motion of the DA to remove. But if you read it differently, I'm happy. If you've got a particular section you think contradicts that, I'm happy to take a look at it.
Yeah, I have a bunch of sections. But the thing is we have to look at, when we write a bill, the different ways it can be interpreted. You would agree with that?
And I have read this, and
that's why.
Given my reading of the bill, my understanding and my reading of it is that it requires the DA's acquiescence in some form before a 16 or 17-year-old can have their case removed. Yeah. One exception would be if there's an arrest, there's a preliminary hearing, and a judge finds there's no evidence to support the felony that got the case into court in the first place. That's a different scenario. But where the evidence supports the charge, the case can't be removed without the DA's
and some of the things that we're talking about here is tampering. The things that wouldn't put it into that category is tampering with a witness, gang assault. There are various sex crimes that are in there that what they're going to do, they can move that right to family court. There's a lot of crimes in there that are serious, that we haven't hit.
I believe the crimes you just listed are crimes that someone would be charged as a juvenile offender for and go to the special youth part as opposed to family court.
Well, there's a list of crimes.
Yes.
So when you go in there, they give you a list, right? And you go into the the law that they direct you to, you go through a list, and basically anything that's not on that list, right, is separate from that. So, I mean, the interpretation is that you're going to switch that to family court, all right? And in some of the sex cases, what happens is if you get adjudicated in a family court, right, so if it's a sex crime, but it gets adjudicated in a family court as opposed to a conviction, you wouldn't be subject to giving a DNA sample, and you wouldn't be subject to registering on a sex offender registry list. Is that correct?
Yes, if your case is adjudicated in family court, those provisions don't kick in. If you're adjudicated a juvenile offender in adult court and you're not given youthful offender, they do. So, I think what this bill has tried to do is balance, trying to get better outcomes for our 16 and 17-year-olds with protecting society from young people who commit horrendous crimes. And I suppose we can argue about exactly where you strike that balance, but I think the bill has been very thoughtful about trying to figure out, what cases should go into each category and create a framework that even within those categories where the judge and the DA are in agreement that someone should be treated differently, it gives a mechanism for that to happen.
Right. I mean, how I'm reading it is if I have a person that's 1 day short of their 18th birthday and they molest a child, it's possible for them to go into family court. And it's possible for them to be adjudicated in family court. And if they're adjudicated in family court 1 day short of their 18th birthday, they don't have to register on a sex offender registry list, and they don't have to supply DNA.
That's if it's a felony sex crime, then that's only with the consent of the DA. And I think you've elected DA in every single county in the state to stand up for your rights and to make decisions like that to protect the community. And this bill, is premised on the idea that DAs do their jobs and do them well, and that they'll review these cases, and they won't consent to removal to family court unless the facts and circumstances of the case are appropriate for that.
Yeah, but there's...
Thank you.
Okay. Thank you.